Lordship, I beg to mention item number 26, supply hearing. Item number 26, with consent from other side. Kindly this matter may be taken after 4 weeks.
Why?
In present case, the learned senior advocate Dilip Majumdar, he will be appearing.
Sure. What is the matter?
Lordship,
What's the sentence?
10 years.
10 years.
Yes.
POCSO.
Yes, Lordship.
On the prayer of Mr.
Ex-Gyati.
Ex-Gyati, learned counsel
2-6.
for the appellant. List this matter after 4 weeks.
Yes, all right.
Yes, I beg to mention item number 24 and 25, madam. With consent of other side, I am praying the listing of matter on 19.5, madam. 19.5
Why 19.5?
19. Other side is from outside, my lord. So
Mr. On the prayer of Mr. El Perme, learned counsel for the respondent.
respondent, my lord, in both the case.
Respondents 24-25, huh? And then on the consent of learned counsel for the appellant, list this matter on 19/05/2020.
High level, sir.
Your Lordship, I beg to mention item number 13. I'm appearing on behalf of V. Jama.
13.
Yes,
What is the matter? What is the matter?
I don't know.
Anyway, on the prayer of Mr.
Sita Jo.
Sita learned counsel appearing on behalf of Mr. B. Jama, learned counsel for the applicant of the appellant. Let this matter be listed after 3 weeks.
2 weeks.
2 weeks, huh?
Always.
My lord, I would like to beg to mention item number 16. It's a criminal revision petition.
Yes.
So it may be adjourned as the leading counsel is out of station and may fix on May 1.
On the prayer of MS,
D. Boni.
learned counsel appearing on behalf of Mr. N. Rama,
Yes, sir.
learned counsel, he is stated to be having some personal difficulty today. This matter on 01/05. This matter after 2 weeks. 2 weeks.
Yeah, Lordship.
Yes.
I beg to mention item number 9.
9.
Yes, Lordship. I have taken consent from the other party on behalf of Advocate R. Sokia. This matter may be adjourned for today and fixed after 1 week.
On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. R. Sokia, learned counsel for the petition. This matter after a week.
Next week, my lord. Next week. My lord.
After a week.
Next week, my lord, there's an interim order, my lord.
After a week. Next week, well, after a week.
Okay.
And use it and on the
Complex.
consent of Mr. El Perme, learned counsel.
May it please your lordship, I beg to mention item number 27 for adjournment. As the main counsel is out of station and matter may list for after 3 weeks, your lordship.
Have you taken consent?
Yes, your lordship. We have communicated with the other party.
Criminal petition. On the prayer of, no, Mr. So-and-so, learned counsel. You are A-tying. You are A-tying.
I'm appearing praying for on behalf of Jyoti Jungluju.
Mr. So-and-so, learned counsel. Appearing on behalf of MS J. Jongluju, learned counsel for the petitioner. Submits that MS Jongluju has some personal difficulty today. Therefore, better is adjourned for 2 weeks, 3 weeks.
3 weeks, your lordship.
Mr. So-and-so, learned counsel for the respondent. is present. Huh? Yes.
Much obliged, Your Lordship.
My lord, item number 20, my
Hmm.
lord, I must admit, my lord, there is a, our clerk has not taken steps on the sole respondent. But I may be allowed to take fresh steps.
Mr. T. Patil, learned counsel for the petitioner. Please, granted further a week's time to take fresh steps upon respondent,
Sole respondent.
sole respondent. This list
Not
of
only
the
one prayer that
Four.
interim order may be till then, my lord.
interim order.
Pass on.
Is the interim order is there?
Yes, interim order.
Interim order was the lesson 30.
My lord, thank you.
May I?
Yes,
Your Lordship, I beg to mention item number 8.
item 8,
Yes, Your Lordship.
yes.
On behalf of the conducting council, Arengo. Your Lordship, due to personal difficulties, he is out of station.
Have
And-
you taken consent from the petitioner?
Yes, yes, Your Lordship. We have taken consent.
On the consent of learned counsel for the petitioner, comma, MS so learned counsel appearing on behalf of Mr. Haring or learned counsel for the respondents. This matter after 4 weeks.
Deeply
4
obliged.
weeks.
Yes, Your Lordship.
May I, Lordship?
Hmm.
Your Lordship, this is a bail application filed under 439 of BNSS
Hmm.
for granting bail, regular bail to the accused person.
Serious
It's POXO matter, Your Lordship.
Yes.
And this matter has already come before Your Lordship, wherein
accused, namely Sri Guddu Kumar, right?
Yes, Lordship.
Who has been in connection with Itanagar woman, this PS case number 03 of 2024, case 1, huh? Who has been arrested on 24/01/2024. Call for the scanned copy of the trial court record. Mr. Theatre and addition PP appears for the state. Respondent number 1, comma, respondent number 1. Petitioner, the learned counsel of the petitioner to take steps for solution of for respondent number 2 and 3 within 2 days. List after when?
Lordship,
matter on-
can it be on 9 of,
it will take time, Your Lord. Notice has to be served, Your Lordship.
Huh?
Notice has to be served, Your Lordship. It's a victim, it's a POXO matter. So 9, Your Lordship, too early.
List the matter on. They are from Itanagar. Can you?
yes, Lordship?
19. Let it be on 19th, Your Lordship, May.
19?
Yes,
Yes, Lordship.
19/05/2024.
both the cases, 1 and 2.
Yes,
Ah.
1 and
Same FIR.
Same FIR, Your
Same
Lordship. Obliged, Your Lordship.
much obliged.
May it please your Lordship. Lordship, this is bail application under section 483 of BNSS, praying for granting of regular bail to the accused person. My lord, the allegation charges accused person is NDPS section 21 and 27.
Less than
Yes,
small quantity.
yes. But one BNS sections is
Available.
yes, 132 BNS is non-bailable, and I have filed bail application before District and Sessions Court UP, but it was rejected. So hence it is application, Your Honor.
And MS J. Dodi, learned counsel for the applicant. This is the application under section 483 of BNSS 2023. Praying for grant of bail to the accused, namely Sri Oling Lego, in connection with Dharma PS case number 49 of 2025, section 280. Page 2, 132. BNS reduce section 21. Is so and so in the case. Call for the case diary. Scan copy or case diary.
Yes, yes,
Scan
yes.
copy of the case diary. Mr. Deloy Leonard. PP. Yes, for the state. List the matter on when? Next week?
Next week,
Next week, Your Honor, 29,
29.
yes,
Huh?
29 for, 29 April,
30. 30.
30. Oh,
30. 0422.
oh, bless.
Please, Lordship. My lord, this is for Jimma application, the vehicle, my lord.
So
The,
what is to be done?
my lord, I think it's almost 7 months, my lord. The accused person is also on bail. Only the vehicle is not out, my lord.
Yeah.
Lordship, earlier, so they applied the Jimma before the court, Lordship, lower court, Lordship, trial court, Lordship.
It has been rejected.
Yes,
That's why we have come.
The IO find that this vehicle was multiple used in the commission of offense, Lordship. That's why they rejected the,
Multiple of it.
yeah,
My lord, that-
similar, multiple times, Lordship.
my lord, that's the allegation that there was nothing on record to, in which cases they were involved, my lord. In that case, my lord, if the same ground, if the accused, if he comes out, he has been involved in so many cases, my lord, then also.
Let's see the records, whatever is there.
Yes, Lord. But one thing, when accused is out, my lord, keeping the vehicle for, it's more than 7 months, that's why, my lord. Otherwise, matter would have been different, my lord.
I was rejecting, Lordship.
Huh?
I was objecting the.
It's okay. I is objecting the, it doesn't matter. Obviously, they will object.
Yes,
I mean, the accused has been released on bail.
yes, already.
So you want that the accused, to prevent the accused to use the vehicle for
Yes, yes, for the.
committing other offenses.
Yes,
Sundar Bhai Ambala was very clear, my lord.
Huh?
Sundar Bhai Ambala judgment maybe is very clear.
That's what I'm
Videography.
asking, is it the law?
No.
Preventive detention of the car. Anyway, we'll go for that.
Yes.
Third, Mr. Pita Learned Counsel for the petition. This is an application under section 520 in the ENS 2023. Against the order that is 0801/2025 passed by the London Special Judge within bracket NDPS UPA. Whereby the Jimma application in connection with Naharlagun PS case number 110 of 2024 under section 21 within bracket B bracket clause of the 27 of NDPS Act, praying for release of the vehicle. Vehicle Tata Nexon car bearing registration number AR01Q0633 on Jimma has been rejected. Since Mr. Deloy London PP enters appearance exit notice of on behalf of state, no moment notice need be served. Mr. Call for the scanned copy of the case diary. CD.
Charge sheet has not chargeable.
Charge sheet has not been filed. No, we'll call for the records.
Yes, please.
Call for the trial records from the, what is this? London Judicial
Special-
Magistrate, no. From the London Special Judge NDPS. The Court of the Special Judge NDPS UPA. List after 2 weeks. 2 weeks.
Yes.
Deplorable.
Husband and wife,
My lord.
settled.
Yes, sir.
Formally call for the trial court records.
That good.
Charge sheet has been filed.
It is
Charge sheet has been filed.
filed and trial is also going on.
Okay.
In the meantime.
Heard Mr. M. Tathalan consent to the petitioner. Petitioners.
Fine.
This is an application under section 528 of BNSS 2023. Praying for quashment of criminal proceedings of GR case number 283 of 2013 under section 498 A oblique 323 IPC 1860 on the basis of the compromise, on the basis of the settlement between the petitioners. Next. Call for the scanned copy of the trial court record. Next, Mr. T. Athilan, additional PP. Appears for the state. So, anything else?
Well, it's the proceeding of the.
Pending production of the scanned copy of the trial court record. The further proceedings of year case number 283 of 2015 pending before the Court of Chief Judicial Magistrate UPA. Shall remain suspended.
Right.
List after 4 weeks.
Obliged, Your Lordship.
Yep, yep.
Lordship, this is a joint application filed by the petition number 1, who is the complainant, and petition number 2 is the accused in the criminal petition for the quashing of the complaint case 20/23, which is pending before the Chief Judicial Magistrate Pasigat, as the petitioners has mutually and amicably settled the matter.
Heard MS Swain, no, no, yes, heard MS Swain Solan consent for the petitioners. This joint application is preferred under section 523 of 528 of BNSS 2023. Praying for enforcement of the proceedings of CR case number 20 of 2023 pending before the Court of Chief Judicial Magistrate Pasigat is on the basis of the under which section?
Your Lordship, Lordship will find in page 4 of their petition, Your Lordship.
Huh?
Page 4 of their petition in para.
463, huh?
Yes.
Para 464, 465, 466, 473 and 474 of IPC. You had that
Lordship,
on the basis of the settlement.
Lordship,
Call for the
Your Lordship, only under section 468 and 471, the cognizance has been taken.
call for the scanned copy of the trial court record. Mr. T. Athilan, addition PP.
Lordship,
Yes, court
may the
is
proceeding be stayed as the proceeding is.
production of scanned copy of trial court record. Further proceedings of CR case number 20 of 2023 before the Court of Chief Judicial Magistrate Pasigat shall remain suspended. List after 4 weeks.
Obliged, Your Lordship.
Lordship.
Yes, sir. Yes,
My lord, I am representing respondent number 2 and 5.
2 and 5.
2 to 5.
What about others? 2 and 5.
2 to 5.
2 to 5. Who is for one? One is state.
State is represented by T. Jamu.
Hmm?
Lordship, I'm for the petitioners.
Yes.
Lordship, today respondent party was taken a consent from us to mention the matter.
Who?
The respondent one.
Who is respondent number 1?
It's government, Lordship.
What government? Who is respondent number 1?
Respondent was Sri Gali Koyu.
Huh?
Sri Gali Koyu.
This is not government.
No, man. There is no comment in party.
There is no government.
No comment.
Sabha Thakur.
Lordship, since I have not well instructed by my senior, this matter may adjourn for today, Lordship.
Why? You have got the list yesterday. When did you receive the cause list?
Yesterday, Lordship.
So,
But today, the respondent party taken
who is
consent from us.
respondent number party? He is there.
Respondent party one.
Who is 1? Are you for 1?
Yes, my lord.
Yes.
Yeah, my lord, I would like to take adjournments, my lord, this ones.
Why?
On the behalf of the Tijamo.
Ah.
And my lord, I will file reply.
You are for why? Whom?
It is not, Lordship.
You are for? Respondent number 1. Who is for respondent number? Your name, please?
My lord, Tigami.
Huh?
Tigami.
T. Gami.
Yes,
Appearing on behalf of
Tijamo.
T. Jamo.
Jamo, my lord.
Okay. So what is to be done?
My lord, that may be given 2 weeks for filing reply, my lord.
What reply? It's
Yes,
the
ma'am.
first appeal. It's the first appeal. No question of filing a reply. Record is there? Has the record been called? No. Hmm?
I have no
Is the
idea.
record required? Hmm? It's a first appeal. Record will be required, I think. Hmm? Yes. T. Tagum, T. Jammu. Yes. Have you not gone through the file? Have you not read the file brief? Modi, you have seen the first order. Well, issuing notice. Have you filed any suit? Have you filed any suit?
My lord, I.
You have no idea.
No well versed of this fact.
Huh?
As per instruction of the Jamo, my lord.
Where is Mr. Jamo?
Tagum Jamo.
Where is Mr. Tagum Jamo?
My lord, he's out of station, my lord. Next, there may be given for final.
Mr.
Titato.
Titato, learned counsel appearing on behalf of Mr.
Titagum.
Titagum, learned counsel for the appellant and Mr.
Jamu.
Your name, please.
My lord, my name is Tony Gambi.
Ah.
Gambi.
Learned counsel appearing on behalf of Mr. T. Jamo, learned counsel for the respondent number 1. Praise that. I have jointly prayed that matter may be listed and after 3 weeks, list of on the ground that their seniors are out of station. List of prayer not being objected to by Mr. O. Modi, and counsel for the respondent number 2 to 5. Come on, list this matter after 3 weeks. 3 weeks. At the first stage, on the first day, for respondent petitioner, respondent number 1 had submitted that they would be filing a suit over the land because it primarily appears that the learned court has wrongly decided the title of the suit in a probate proceedings. Think about it.
Yeah, Lordship.
Yes.
Lordship, in this matter, the informant complainant, that is petitioner number 3 and the two accused, that is petitioner number 1 and 2, have fully and completely settled the matter. Therefore, they have jointly filed this criminal petition for quashing of GR case number 342 of 2014, corresponding to Itanagar PS case number 138 of 2014. Lordship,
Charge sheet has been filed.
yes, Lordship.
Where's the charge sheet?
It's in page number 15, Lordship.
15.
Annexer 2.
Yes.
Lordship, in this matter, the other accused person have not been appearing in the trial court below, for which the case has been prolonged delay.
Yes. How many petitioners?
Petitioners 3.
3. 3 of them have been charge sheeted.
Lordship.
Charge sheeted.
Yes, Lordship.
What is the stage of trial?
Appearance, Lordship.
Evidence.
Appearance.
Appearance.
Yes, Lordship.
Yes.
Lordship, they already settled the dispute, Lordship.
Huh?
They already settled your dispute, Lordship. By amicably, deed of settlement, Lordship, at page number 38, Lordship.
30?
Page number 38, Lordship.
38.
Yes, Lordship, annexer 3, Lordship.
Yes. What is this?
Deed of
Amicable
settlement, Lordship.
settlement agreement.
Who is the complainant?
Complainant is Lordship Ajit Nacho.
Ajit Naso. And what about the other party? Third,
They are president and GS of APSU.
it's okay. There are three persons,
Yes,
three
Lordship.
petitioners.
Yeah, yes, Lordship, but the settlement is also only one person.
Huh?
Settlement agreement is between only 2%, Lordship.
That's what I'm saying.
Yes, Lordship.
Hmm? What about the others? There are how many charge sheet against how many persons? Three,
Uh,
two,
No, Lordship. 7.
seven. Then
Lordship, 3 accused have not been appearing in the lower court below. Because there is no such person by that name.
hmm?
Because there is no such
How do
person
we
by.
know?
Lordship, since 2014, they have been issued notice after notice for appearance, but they are not appearing.
Page, persons of the groups. of five, one to five, This is by Kamta Lapung and Biri Nasi.
Biru Nasi.
Biru Nasi.
Yes, Lordship.
Huh? Can we quash against these two accused? Because they have been charged under section 10447 separately.
Lordship under 109.
Yes,
Lordship,
as abettor.
Lordship, this matter may kindly pass over for the time being, Lordship, since Elagi is appearing this Lordship.
You are PP, what's there?
Yeah, yes, that's it, but he's
Why
on
not?
the, he's,
Yes.
she is on the way, Lordship.
What do we say? No, there are 7 accused,
Yes, Lordship,
all right?
yes,
And out of that 7 accused, 2 have approached this court
yes,
separately because they have been charged particularly as an abettor,
yes,
109.
yeah.
What do you say?
This would be the.
Because once we quash the proceedings will go. Can the proceedings be quashed against some of the accused? Yes, you, El Hage, you and Mr. Ate, you discuss.
Yes,
We'll
my
take
lord,
after some time.
yes,
We'll take after some time.
yes.
PP, you discuss what is to be done. Otherwise, and then what is the law on that issue?
Yes, sir.
Because if we quash, entire proceedings will go.
Yes,
Or can we quash in respect of the petitioners only? Find out.
The petitioners cannot become in piecemeal basis, Lordship.
Huh?
So we cannot approach this in piecemeal basis.
No, it's not a question of piecemeal. You discuss.
Yes, sir.
You find out the case law. Understood?
Yes.
What is the query, I mean, the issue I've raised? There are 7 accused.
Yes.
All right?
Yes.
And the present petitioners, the two petitioners in this case has been charged as an abettor under section 10, including those 447, 448, 109. So in that case, can we quash the proceedings against these two petitioners? Because we will not be determining the other accused because they are not before this. Affidavit not yet filed. Who is for the respondent? Huh? So, okay, heard Mr. T. Tapak, learned counsel for the petitioner, and Mr. O. Modi, learned counsel for the sole respondent.
Sole respondent.
There are two respondents.
One
No, for respondents, huh? As agreed to be learned, counsel for the parties, this matter for after 2 weeks.
admission here. All right.
Not appears for the petitioners on call, petitioner on call, Mr. So and so, this Louis Leonard, public prosecutor is present. Await service report, list after 4 weeks.
Step has been taken, my lord.
Let us see, steps.
Yes. OP.
Answer notice returned back to this in respect of sole respondent with postal notice address out of station and same is kept with them. What does it mean by out of station? You take a press step. Heard Mr. So and so learned counsel for the petitioner. Huh?
Yes.
Next para, office note dated 23/04/2025 discloses that answered notice has been returned, answered notice in respect of respondent number, sole respondent or what?
Yes,
Sole
sole.
respondent has returned back. Mr. Next one, in view of Mr. So and so learned conflict of the listeners to take a steps for submission, to take press steps for submission notice. Sole respondent within 2 days. Just after 4 weeks.
Within 7 days.
Why 7 days?
Because I have to photocopy the photocopy.
Within 7 days. Then list after 5 weeks.
Offline.
Hmm.
Offline.
Same person. They mentioned attempt 16. Huh? Same order in item 16, huh? Item 16, they mentioned same. What is the case? Huh? No, not up to 18. 15, 16. Huh? Same case. Why this revision petition? Article Islam. They mentioned item 16, so same order, 15. On appeals for the petition on hold, this after 4 weeks. Mr. Deloy, London Edison PP, the London Public Prosecutor is present, huh? Non appeals for the petition on call, Mr. Deloy, London, next pair, huh? PP is present. List for admission hearing after 4 weeks.
Your Lordship, I'm for the petitioner. We won't be filing any affidavit in reply. Kindly, any fixed date may be given for admission hearing.
So and so and counsel for the petitioner.
Yes, Your Lordship. After 4 weeks, Your Lordship, matter may be fixed.
And Mr.
HAP.
Huh?
HAP.
H.
APE.
Ape.
Yes.
Land council for the restaurant, and agreed to by land council for the party, list this matter after 3 weeks
Maybe fixed for here.
for admission hearing.
Any
Admission,
admission hearing, any fixed date may be given.
after
Fixed
3
date.
weeks, 3 weeks, after 3 weeks. All right?
Complies.
Yes, sir.
In the this application, I'm praying for passing of the FIR and charge sheet that is registered against me, and that is pending before the learned court of CGM 0. And I'm charged sheet is under section 454 and 380 IPC. The facts in this case, your Lordship is that on 16/5/2024, the petition number 1, that is the accused, he entered into the house of the complainant and he stole some amount from the house of the complainant. Subsequently, FIR was registered against me and I was also charged with it. So, but now the matter has been settled between the parties and I have compensated the opposite party. I have paid the amount, paid the amount to the opposite party. May I please take your Lordship to the deed of settlement? There is in page number 44, your Lordship.
44.
Yes, your Lordship.
Where is 44?
That is the direct settlement. Yes, election number 3.
Settlement.
Yes, your Lordship.
Sirimuti Duyun Nimang
Jimu. Yes,
Jimung.
your Lordship.
Kago Nipa. Yes.
They have settled the matter, Lordship, I have no objection.
Heard that so and so, land council for the
The
N Kago. And the K Kajan,
petition.
land council for the petitioners. And also heard Mr. D. Learned Edison Public Prosecutor for the state. This is an application under
528. 528.
yes. Fast.
Thank you, Lord.
Complies.
Dispose of liquid.
My Lordship.
Yes.
Lordship, we need to take instruction for Lordship, the appellant has passed away, Lordship, so we need to take instruction from his family.
Appellant.
Yes, Lordship. T Jamo, Tamur Jamo, Lordship.
Mr. In both the cases,
Yes, Lordship. In item number 22, respondent, Lordship. And R23, appellant.
okay. Mr. Your name please?
T Darin, Togga Darin,
T. Daring, appearing on behalf of Mr.
D Pangin.
D. Panging,
Yes, Lordship.
who has died?
Tamur Jamo.
The on behalf of Mr. Deepang, Land Counsel for the appellant, in RFA 3 of 2018, item 22, submits that the appellant, submits that during the pendency of this appeal, these appeals, the appellant, namely, the appellant has died, has expired. Therefore, he prays for some time to take steps and assess spread for adjournment of the matter for 4 weeks, 3 weeks,
2 weeks, Lordship.
2 weeks. In view of the above, let these appeals are adjourned for 2 weeks. List after 2 weeks.
Deeply blessed.
Timing. Yeah. Item 21. Came on, huh? Okay. Item 10. Yes.
Some more time, Lordship.
Huh?
Some more time. Yes.
We'll sit after 15 minutes.
Yes.
11:30. Huh? No, 15 minutes. 15 minutes. He is seeking some more time. 10, 11:30. After 15 minutes.
Yes, Lordship.
All right. You sent somebody to correct that. That's all.
Lordship, as the parties have completely and fully settled and compromised the matter, this GR case may be quashed. GR case number 342 of 2014 may be quashed in the interest of justice. Lordship, as they have fully and completely settled the matter by paying the repairing cost of the vehicle, which was damaged during the 12 hours ban call. And settlement agreement has also been executed between the parties. So in this regard, Lordship may kindly question. Lordship. Sir, Lordship, it was paid during the pendency of investigation, so Lordship, repairing cost and other expenditure were paid, so the parties. Sir, Lordship, it's not there, but that is the reason they have executed the settlement agreement, Lordship. Page 30.
Yes.
Lordship, here the case Lordship, this is compoundable offense Lordship. First thing Lordship. And second Lordship, this FIR is lodged Lordship against the two-person Lordship. But during the Lordship trial, the GR case where the trial is going on, there's yes Lordship. Yes Lordship. And Lordship, they have yes Lordship. This is the Lordship main point Lordship, because Lordship, they only between the parties who have settled Lordship, if the FIR and the trial is within themselves, then it would be Lordship, okay Lordship. But here the other persons are also being involved, or found to be involved, and trial is also pending with them. Because at that time they were the secretary. Yes, Lordship. Yes, Lordship. And during the trial, Lordship, all the other persons are also they have found to be Lordship involved Lordship. So their appearance is Lordship in the pending Lordship in the trial court. Yes, Lordship. That's why Lordship enter. Yes, Lordship. So Lordship, first of all, Lordship, in the Lakshmi Narayan Lordship, where in the matter is Lordship in the compoundable offense. Yes, Lordship. Yes, Lordship. 340, 447 or 427.
Yes, my lord. This issue has already came before the Supreme Court now, Your Lordship.
Yeah.
Your Lordship, earlier this issue has raised before the single bench of the Punjab High Court, wherein Your Lordship, learned single bench has referred the issue to the larger bench. The issue was, Your Lordship, whether bearing in the mind in the repercussion attached to the partial quashing of FIR, partial quashing, on the trial of the other co-accused, can a partial compromise yet constitute the ground for quashing of FIR only qua some of the accused? First issue. Second issue, would partial quashing of a criminal proceeding on the strength of partial compromise elevate the status of victim from that of a stakeholder to that of the driver of the criminal justice system? Now, Your Lordship, answer to this reference by the division bench of the Punjab High Court.
Sections are compoundable Lordship. Yes, Lordship. 427, 447, and 34 Lordship for compoundable Lordship.
109 is non-compoundable. Now, Your Lordship, the answer to the reference in para 26 of division bench, Your Lordship, this is judgment, Your Lordship. Para 26, Your Lordship. Yes, Your Lordship. May I read? In sequel, when thereby the learned trial judge concerned may be led to pronounce a verdict of acquittal vis-a-vis those who remain omitted to be mentioned in the piecemeal order of composition, as made post a piecemeal settlement, becoming recorded amongst the concerned. In consequences, besides, naturally havoc would be caused not only to the criminal administration system, but also to the threat underpinning thereof, that no damage occurs to the moral conscience of the society, nor the conscience or moral conscience of the society becomes second. It is but to avoid the above ill casualties or the ill situation supra, the Honorable Supreme Court has in the verdict supra thus has made supra guidelines whereby, but obviously there is a requirement of exercising of self-restraint by the High Court in receiving piecemeal settlement, and also subsequently in making piecemeal order of composition reiteratedly the ill effect of receiving of such piecemeal settlement and also the making of consequent thereto piecemeal order of composition thus naturally would be above. In sequel, issue number 1 is answered accordingly. In some situation, as stated supra, the victim may attempt to be the driver of criminal justice system, but to ensure that the victim complainant does not become the driver of the criminal justice system through making of piecemeal settlement. Thereupon, the court are required to be not accepting any piecemeal settlement, rather are required to be rejecting piecemeal settlement, nor they are required to be making piecemeal order for the composition of offense. Issue number 2 is answered accordingly. Now, Your Lordship, this order was challenged before the Honorable Supreme Court. This is the, Your Lordship, order of the Honorable Supreme Court, Your Lordship. Now it is still pending, sub judice, Your Lordship. The issue to be considered here is whether on the basis of compromise reached between the informant and the petitioner, one of the accused, on dated so and so annexer P2, the quashment of the FIR on the petition filed under section 482 CRPC should have been ordered by the court. In this case, the petitioner was not named in the FIR and was roped in on the basis of the statement by the co-accused. On the legal aspect, the counsel drew the attention of court to the chart of page D to the point out that different high court has taken contrary position of the issue as to whether on the face of the compromise with one of or few of the accused in the case can be part quashed by the court. Issue notice returnable. Now it's pending before the Honorable Supreme Court, Your Lordship. Yes, Your Lordship. Yes. Yes. Earlier also, Your Lordship, here the coordinate bench has quashed some matter on piecemeal settlement because we were not aware of this case laws and the yes, not this bench, but the other coordinate bench. So now we are facing problem because the other are coming on merit of the case now. They are not entering into the settlement. This is the difficulty, Your Lordship.
Well, the difficulty is, as we have already mentioned in, including petitioner number 2. Well, if Lordship, my Lord, correct, my Lord. Correct. 2 and 3 affidavit authorized, my Lord. Yes, ma'am. One and 3, madam. Correct, madam. Yes, yes. Two accused person. That we have categorically stated that out of 7, 3 are not exist, madam, and 1 is expired. Yes, please.
Can't find it.
Voluntary. Madam, that is the my lord, difficulty we faced, my lord. Only 3 accused persons have not exist. Because of that reasons, the trial is prolonged. And time and again, no, there is no percentage. That is, yes, madam. Therefore, in the trial court, madam, direction was given to the PP to ascertain the name of the accused, those accused persons who failed to appear before the court. Madam, the Onsan police station had given a remark, there is no person as judge by name there. Madam. Yes, madam. I'll do that. Civilization. But madam. Madam. And to my respectful submission, madam, it is not a piecemeal settlement, madam. It is only one, yes. Yes, madam. Madam. Yes, madam. I'll come. Correct. Yes.
Your Lordship, on merit, definitely can be done, Your Lordship, on merit. If case is not made out, even if there is settlement, court can, on merit can quash the matter.
On listening to the facts, piecemeal settlement is not permissible. But then that. The thing is, whether it is a piecemeal or not, it has to be.
Your Lordship, only both the accused.
But they. Yes.
Because, Your Lordship, what will be the consequences later on? Your Lordship, just my humble, Your Lordship, understanding is, which we have faced here in this, by the coordinate bench, where there was two accused. With one accused, the victim has compromised the matter. But the other one, they are not ready to compromise it. He came and the other victim came and challenged that FIR, Your Lordship. Now the court has to consider the FIR on merit. Yes. 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 Yes, only in respect of him, it was quashed. But later on, the other came and he challenged on merit because the party is not ready to settle the matter. It's pending before this honorable court, and this court has not find any, Your Lordship, way to find it out. The court has just give them time to try to settle the matter.
Well, my case is slightly different. It's because the damaged part has already been compensated. So therefore, there is no separate issue regarding that part, madam. Other accused persons, my lord, we have already stated in our pleadings that, my lord, I'll come with the regard. Yes, madam. In the meantime, my lord, the proceedings of the, my lord, maybe. No.
What you said?
Yes.
Yasmin Rao. Lordship, page number 15. 15.
Section 109, 447, 447. Pending before the-
PGM. Yes, Lordship.
The basis of this. And number 1 and 3, right?
Yes, Lordship.
1 and 3. By which the petitioner number 1 and number 2 that they are coming to the settlement. The and there are 7 accused persons who have been charged with even the petition number 2 the also party to the
Lordship, and in the meantime, Lordship, trial before the CGM court may be suspended. Three forty-two of 2014, Lordship. 342 of 2014.